Welcome to this hearing of the Subcommittee on Antitrust, Competition, and Consumer Rights. Today we're pleased to hear from 5 distinguished witnesses who will be testifying about competition law approaches to monopoly and abuse of dominance in the U.S. and in the European Union. We welcome each of you and we thank you for your time. We're grateful that you're willing to come and spend some time with us today to educate us on these matters. An assumption has been prevalent in certain circles, including some of our colleagues on Capitol Hill, that America has a monopoly problem. Armed with this assumption, pundits and politicians demand that antitrust enforcers confront these alleged monopolies. Often these proponents of more interventionist antitrust enforcement cite the European Union as a model for how U.S. enforcers should proceed. The question of whether America has an extensive monopoly problem is a topic for another hearing and not one for today. Today we're going to focus on how European competition law compares to U.S. antitrust law on the subject of monopolization, what the Europeans call abuse of dominance. And the European Commission, the EU's administrative body, has certainly been active in prosecuting companies for allegedly abusing their dominance of European markets, especially in the area of high tech. The EU has leveled fines of billions of dollars on firms like Google, Microsoft, and Intel. In September, the European Commission announced that it would now investigate Amazon. Regardless of whether the U.S. might need stricter antitrust enforcement, I believe an understanding of the history of the institutions and the goals that shape EU competition law enforcement and how those factors differ from the U.S. experience might well be critical to judging whether American antitrust enforcers should follow Europe's lead. In particular, I look forward to hearing about the impact that EU competition law enforcement has on U.S. businesses and what that means for American consumers. As I've said before, a competitive marketplace requires a strong antitrust enforcement, a strong system of antitrust laws with consistent, conscientious enforcement of those laws. However, that enforcement has got to be sensible and needs to be grounded in objective economic analysis. Antitrust policy should serve the interests of consumers rather than being a tool of competitors to punish their rivals who happen to be successful. Moreover, interventionist antitrust enforcement that is poorly conceived could have long-term serious effects on the economy and on American consumers. In particular, we don't want to pursue antitrust policies that might undermine the innovation that has long served as the engine of the American economy and fostered the development of the greatest economy the world has ever known. Nor can we afford to return to an antitrust policy based on the subjective political and social goals of unelected bureaucrats, influenced perhaps by utopian ideas or special interest groups. I look forward to discussing each of these issues with you today. Senator Klobuchar, the ranking Democrat on this subcommittee, will now deliver her opening statement.
Thank you very much, Senator Lee, and thank you for holding this hearing. I think it'll be useful for us to learn about what is going on with the European rules and regulations. But I do want to make clear that you and I both share an interest, a strong zeal for looking at our antitrust laws, but I don't really see this as should we follow Europe's lead. I think we need to take our own lead, period. It doesn't have to look exactly like what they're doing in Europe. It may be different, but right now we are at a moment of paralysis when it comes to really moving forward on one, antitrust enforcement, and I do appreciate some of the efforts of the Justice Department and the FTC, but the court rulings have become so conservative that it has become on the Supreme Court level with 2 new justices that have even more restrictive views of antitrust laws. I think it is becoming harder and harder for us to go that route when you look at the fact that we've seen a 50% increase in merger filings in just the last 5 years. So when I look at what we are doing in America when it comes to legislating on this issue, we are really not doing anything at all. And I think that we need to do something to better equip the agencies to be as sophisticated as the people that they are regulating and the trillion-dollar companies that are coming into their doors. And then I also think we need to look at changing some of the standards for the changing environment we're in with monopsonies. Secondly, when you look at the New York Times story today on what is happening with Facebook, we also have to look beyond antitrust to privacy regulations and put something in place there, which we haven't done. We've literally been paralyzed. And also that we need to do something more when it comes to political ads and things that are on social networks. So I appreciate very much this hearing so we can find out what Europe is doing, but I don't think the frame and the question really is, should we follow their lead? The question should be, are we taking any lead at all? And I don't think we are. I think we have ideas out there and bills, but our country has not done anything to protect ourselves and competition and innovation for what is coming at us. Why? Well, first of all, there is global attention on the effect of powerful firms on competition, and that is a good thing that we're talking about this and that the chairman has called this hearing. European enforcers are issuing, as we know, record fines to some of the world's largest companies for abusing their dominant market positions. In our country, according to the Pew Research Center, 2/3 of Americans have come to believe that the economy, quote, unfairly favors powerful interests, end quote, leading to calls for more vigorous antitrust enforcement. Another factor. Second, we are experiencing technological change that is both reshaping the global economy and concentrating power in the hands of relatively few companies. As a result, both the European Commission and the U.S. antitrust authorities are faced with the challenge of protecting competitive markets while preserving incentives to innovate. At our last hearing, I mentioned that my favorite game growing up was Monopoly. I made the point that now 90% of freight traffic in our country is handled by only 4 Class I railroads, which happens to be the number of railroads on the Monopoly board. I don't think that's a coincidence anymore because we're seeing that kind of consolidation as well as new media consolidation like we've never seen. But with these benefits that we've seen of some of the breakthrough technology comes the exploitation of monopoly power and the ability to charge inflated or discriminatory prices, which we have seen some with the railroads. And then when you look at the past, our country intervened. Sometimes it took decades to get the Sherman Act passed or to start enforcing it while it was on the books and lay dormant. But we did something. And right now, I fear we are entering this moment in time without even considering doing anything about changing our laws to meet the challenges. Third, enforcement directed of monopolization, what Europeans call abuse of dominance, is the area in which we are seeing the biggest differences between the U.S. and Europe. Critics of the European competition law have often said that the U.S. protects competition while the EU props up inefficient competitors. This is a critique that one could make, but as Assistant Attorney General Delrahim recently noted, both U.S. and EU enforcement is economics-based and directed at protecting competition and consumers, applying a consumer welfare standard. So we do have things in common, even though our approaches may be different. But in the area of single firm conduct, there are real differences. The European Commission and member state authorities have been issuing significant fines and initiating investigation against some of the world's largest companies, including Google and Amazon. The U.S. agencies have been far less active in this area. A number of reasons have been raised to explain the difference in enforcement activity. Some have pointed to differences in substantive law, institutional differences making enforcement easier in Europe, or differing attitudes toward monopoly power. Others blame supposed European bias against successful American firms or a reluctance in the United States to challenge our own companies. We need to get to the bottom of what the factors are, and I'm looking forward to learning more about what Europe's doing. But honestly, the last time I checked, we tended to try to take the lead on these issues in this country. Our country is based on innovation. Our country is based on competition. You go back to Adam Smith and the founding of economics in this country and what we were focused on, and that was making sure that we didn't have dominance by one firm or have the take over a certain area. And what I fear is there is a connection between what we all read in the New York Times when we got up this morning and the fact that we're not doing anything and seem afraid and inept at trying to do anything, not just with antitrust, but also privacy law and everything from campaign finance on. Supreme Court cases like Brook Group, Trinco, Legion, and most recently Ohio v. American Express have made enforcing our antitrust laws, which is also part of this whole theme, more challenging, and recent changes to the makeup of the court, as I noted, will accelerate this trend. So it's really up to us to take action to ensure tomorrow's antitrust laws can effectively protect competition. I think that we can learn lessons from what Europe has done. I don't think that means that we need to, as the chairman said, follow their lead. I think we have to break out on our own and start leading, something that we're not doing. I want to thank you very much, and just note that one of the themes that I'm going to bring out as we question is innovation, because I think sometimes it's viewed as, antitrust law enforcement is viewed as somehow limiting innovation. It is, of course, just the opposite. The whole reason we have antitrust laws is that we want to promote small business and competition and innovation, and we can't do that if one company is buying up everyone, if one company is dominating either horizontally or vertically, and it makes it impossible for new players to get into the market, and at the same time has this, what I consider hideous effect, that the Congress is not stepping in and trying to protect consumers in this country, whether it's from prices or whether it is from protecting their own privacy invasions like we read about today. Thank you, Mr. Chairman.
Thank you very much, Senator Klobuchar. We're now going to turn to our witnesses, and I'll introduce each of them briefly. William Kovacic is the Global Competition Professor of Law and Policy and the Director of the Competition Law Center at the George Washington University Law School. He's also a visiting professor at the Dixon Poon School of Law at King's College in London. Since August 2013, he's served as a non-executive director on the board of the United Kingdom's Competition and Markets Authority. From January 2006 to October 2011, Professor Kovacic was a member of the U.S. Federal Trade Commission, which he chaired from March 2008 until March 2009. He also previously served as the FTC's general counsel. Jeffrey Manny is the founder and president of the International Center for Law and Economics, a nonprofit, nonpartisan research center based in Portland, Oregon. He's also a distinguished fellow at Northwestern Law School's Searle Center on Law, Regulation, and Economic Growth. Prior to founding ICLE, Mr. Manny was a law professor at Lewis and Clark Law School. Earlier in his career, Mr. Manny practiced antitrust law with Latham and Watkins. Eleanor Fox is the Walter J. Derenberg Professor of Trade Regulation at New York University School of Law. She served as a member of President Clinton's International Competition Policy Advisory Committee and as a commissioner on President Carter's National Commission for the Review of Antitrust Laws. Professor Fox has advised numerous jurisdictions on antitrust, including South Africa, Kenya, Russia, Poland, and Hungary. Before joining the faculty of NYU Law, Professor Fox was a partner at the New York law firm of Simpson, Thacher, and Bartlett. Tad Lipsky is currently an adjunct professor at George Mason Antonin Scalia Law School, where he also serves as the director of the advocacy program of the Global Antitrust Institute. He served as the acting director of the FTC's Bureau of Competition between February and June of 2017. Before joining the FTC, Mr. Lipsky was a partner with Latham & Watkins for 15 years. He previously served as chief antitrust lawyer for the Coca-Cola Company and of the antitrust division of the Reagan administration. Jonathan Cantor is a partner and co-chair of the antitrust group at Paul Weiss, where he focuses on antitrust mergers and acquisition, litigation, and counseling. He currently represents some of the world's most notable media and technology companies, including news publishers, digital media agencies, providers of online services, and streaming data providers. Mr. Cantor previously worked at the U.S. Federal Trade Commission's Bureau of Competition. So before we begin, I'd like to swear in each of our witnesses. If you will stand and raise your right hand. You swear that the testimony you're about to give before the subcommittee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Professor Kovacic, we'll start with you. You may begin.
Chairman Lee, Ranking Member Klobuchar, Senator Blumenthal, I'm grateful for the opportunity to participate in these proceedings. I applaud the custom of this subcommittee, which goes back at least a half century, of doing comparative study, especially with a focus on the European Union and the U.S. systems. From 1975 to 76, I was a research assistant on the majority staff of the subcommittee under the chairmanship of Senator Philip Hart, and I saw firsthand the benefits of the committees conducting these kinds of deliberations. Why compare the experience of the two jurisdictions? First, they are the two most influential jurisdictions in setting global standards for the treatment of anti-competitive behavior. The U.S. relationship with the European Union is uniquely significant. It's the most important bilateral relationship that the United States has in this field, and the European Union indeed has become the leading jurisdiction in the world, influencing the setting of global policy and standards. All reasons to perform this comparison. I want to focus on three features of the two systems to provide a framework for our conversation today about how the two systems relate to each other. I'd like to talk a bit about goals. I'd like to talk a little bit about the legal framework and current enforcement policy, and I'd like to talk a bit about process. And in doing this, I'm giving you my views, not those of the Competition and Markets Authority in the UK, where I do serve as a non-executive director. First, the question of goals. As Senator Klobuchar said, I think both institutions on both sides of the Atlantic have expressed consistently a commitment to what might broadly be called a consumer welfare approach. There are also subsidiary aims in the European Union involving market integration as a central goal of the operation of the treaty and the community as a whole, maybe less important in the area of abusive dominance and in the treatment of agreements. There's a basic question about what consumer welfare means, and you've had your own deliberations on this topic. The FTC has had elaborate hearings on this. What does this mean? I think there's a common view in the two jurisdictions about what it does not mean. It does not include the protection of competitors as an end in itself. And I think enforcement officials on both sides of the Atlantic would join arms and say, we are not in the business of protecting firms simply to protect their own position in the market. Second, there is an intense debate going on in agencies on both sides of the Atlantic about what this concept should mean going ahead. Should it embrace a wider array of values? Should it emphasize more than just price effects, look more expansively at innovation? I'd say that debate is taking place today and it will continue. I don't see a great difference in the emphasis that the two institutions on both sides of the Atlantic place on their overall objections. I do want to discard one interpretation. It is often said by top political leaders in both jurisdictions that each set of institutions is committed to bending to political pressure and protectionist impulses as a key source and motivation of enforcement. I reject that. I don't think that motivates the Federal Trade Commission, the Department of Justice, or DG Competition or the European Commission. Matters involving Google provide a good illustration. The FTC, why did it walk away from the case? Because I think it thought that the doctrinal obstacles of bringing a successful case were foreboding, and it came to its own conclusion based on an examination of evidence that the competitive effects of the challenge behavior were not severe. In the European Union, why did they proceed? I think they had confidence that they could bring a successful case in their courts and that bringing a case would improve economic performance. There was a disagreement, perhaps, about the analysis of the underlying facts and the effect of the behavior. There was not, in either instance, I'm confident, a caving in to political pressure or giving in to a sense of protectionist impulses. I'd like to put that interpretation of goals and aims aside. I don't think that motivates what these competition professionals do. What about doctrine? I think there is a shared commitment to the application of sound economic principles. Indeed, in recent ECJ cases like Intel, we see a move away from presumptions that give decisive effect to specific behavior and an inference that adverse competitive effects always follow from that. I would say, as our colleagues have mentioned today, as the members of the panel have said, the EU system is more intervention-minded. They have brought more cases. There have been a higher tempo of activity. Why is this? It's partly rooted in Article 102 of the Treaty on the Functioning of the European Union, which provides an express mandate to do more things than the U.S. system does, to attack unfair purchase or selling prices, to challenge excessive pricing. These are provisions that do not have a counterpart in the U.S. law, and it explains why there is a greater capacity and freedom based on interpretation of the courts in Europe to challenge predatory pricing. There's no recoupment requirement. To impose a broader duty to deal, and duty to deal on non-discriminatory terms. In short, yes, indeed, the European framework is more intervention-minded, and the legal framework provides that foundation. In the U.S., there is very broad freedom for dominant firms to choose pricing, product development, and marketing strategies of their own choosing. This isn't unlimited. Indeed, the FTC is running two very important cases now. One's called Qualcomm, that involves the boundaries of the U.S. framework. What explains the differences? There's the well-known influence of economic and legal perspectives of the Chicago School. But I'd emphasize for you two other things that have happened in the U.S. One, a broadly shared concern that deals with centrists and across the board in the Supreme Court with the impact of private rights of action, the sense that they over-deter in the U.S. system. This is shared by Harvard as well as Chicago, and it's been accepted by the Supreme Court in cases like Brook Group and Trinco, which had a broad consensus when it comes to this fundamental issue of over-deterrence. The FTC Section 5 provides a broader framework for enforcement, but basically that has had a very limited effect, has been given a very limited interpretation by the courts. In short, if this concern were not so prevalent, I'm convinced that the U.S. framework would be more expansive and would much more resemble the EU approach to enforcement. I'd finish by saying that the EU quality control mechanisms tend to be more front-loaded. In some ways, they're more robust than the U.S. system. The obligation to explain outcomes, greater rights for third parties to complain and challenge enforcement decisions. I think that the differences in terms of quality control tend to be exaggerated, but I do welcome your questions and comments on all of these issues as we go ahead. Thanks again for the chance to be here.
Thank you, Professor Cavazza. Mr. Manning.
Oh, yep, sorry. Thank you, Chairman Lee and Ranking Member Klobuchar. Thank you for giving me the opportunity to testify today. The urge to treat antitrust as a legal Swiss Army knife capable of correcting all manner of economic and social ills is difficult to resist. Conflating size with market power and market power with political power, recent calls for regulation of large businesses are often framed in antitrust terms, even though they are rarely rooted in cognizable legal claims or sound economic analysis. But this attraction to a powerful regulatory tool is precisely why we should care about the scope, process, and economics of antitrust and its politicization. For the last 50 years or so, U.S. law has developed a position of relative restraint in the face of novel, ambiguous conduct, while the EU tends to read uncertainty as the outward expression of a lurking threat. In spite of, or perhaps because of this, many assert that the U.S. should emulate the EU in its approach to competition policy. Today, I'd like to call your attention to 4 themes that define the key areas where the two regimes diverge and where the EU approach is less likely to serve consumer interests. First, the EU tends to address antitrust issues within a precautionary principle framework where the U.S. takes an error cost approach. Differentiating pro-competitive from anti-competitive conduct has always been the central difficulty of antitrust. When the very same conduct can either benefit or harm consumers depending on complex and often unknowable circumstances, the cost of over-enforcement is at least as substantial as the cost of under-enforcement. The U.S. Supreme Court has repeatedly recognized that false positive errors might even be greater than those attributable to false negatives because the economic system corrects monopoly more readily than it corrects judicial errors. The EU's precautionary principle approach is the antithesis of this. It's rooted in a belief that markets are unlikely to function well in general and certainly not sufficiently to self-correct in the face of monopolization. Now, no one believes that markets are perfect or that antitrust enforcement is never appropriate. The question is the marginal comparative one. Given the limits of our knowledge and the errors it can lead to, are we better off with a more discretionary regime or one in which enforcement is limited to causes of action we're fairly certain will serve consumer interests? This is a question about changes at the margin, but it is far from marginal in its significance. Second, the EU antitrust rests heavily on presumptions of harm, where US courts require a demonstration of actual anti-competitive effects. The US approach is more consistent with the learnings from modern economics, which nearly universally counsel against presuming competitive harm on the basis of industry structure and in favor of presuming benefit from vertical conduct. The EU approach often disregards these findings and presumes the contrary. Even the EU's highest court, as Bill mentioned, has finally recognized the paucity of the Commission's analysis in this area in its Intel decision. But because judicial review of antitrust decisions in the EU is so attenuated, it's not clear if the High Court's admonition will actually affect the Commission at all. Third, the EU penalizes the existence of monopolies where the US prohibits only the extension of monopoly power. US monopolization law prohibits predatory or exclusionary conduct that actually results in harm to consumers. The EU, by contrast, also regularly punishes the mere possession of monopoly power, even where lawfully obtained. Indeed, the EU even goes so far as to target companies that may lack monopoly power but merely possess an innovative and successful business model. For example, in actions involving companies ranging from soda manufacturers to digital platforms, the EU has required essential facilities-style access to companies' private property for less successful rivals. Fourth, and crucially, competition policy in the EU is purposefully subject to politicization, while political and non-economic aims are not a part of US law. The European Commission is a policymaking body charged with enacting the Commission President's agenda. As such, the goals of European competition enforcers are both diverse and often untethered from economic thinking. For example, under Article 102, firms can be liable for practices that are unfair, prejudice consumers, place trading partners at a disadvantage, or impose obligations that depend on the behavior of other non-contracting parties. Not only are these broad categories sometimes mutually exclusive, but many of the concepts are almost impossible to translate into economic thinking. The result is that EU regulators can readily pursue cases that best fit within a political agenda rather than focusing on the limited practices that are most injurious to consumers. Endorsing a European-style approach to antitrust in order to justify high-profile cases against large internet platforms would prioritize political expediency over the rule of law and consumer well-being. The risk of a more EU-like approach is that it will end up thwarting technological evolution and enshrining mediocrity in the digital economy, where innovative practices with positive welfare effects can be easily demagogued, especially by inefficient firms looking for a regulatory leg up. I urge this committee to consider not just whether the EU approach seems to permit the government to reach a preconceived outcome, for example, placing large tech platforms under increased antitrust scrutiny, but whether it is in fact truly desirable to try to emulate the EU's approach. Thank you.
Thank you very much. Professor Lipsky.
Thank you. And I'd like to echo Chairman Kovacic in thanking you, Chairman Lee, and Ranking Member Klobuchar. I also am familiar with and very much appreciate this long-run and very beneficial function that the subcommittee has played in airing a lot of complicated policy issues that arise in antitrust over the years, and I'm very honored to be included in this process. Now, as in the holiday spirit, I'm going to try to be even shorter in my summary than I intended to be, because I think that Professor Manny has done a fantastic job in highlighting some of the differences in doctrine and in substance. I want to focus on something that is only recently becoming a little bit more of an issue in the discussion about the differences in international antitrust regimes, and specifically between the U.S. and the European Union. It needs to be appreciated that the more interventionist and somewhat more uncertain approach of the European Commission is enhanced by what I would regard as a number of weaknesses in the EU institutional setup, referring both to the Commission and to the EU courts. And let me just highlight what I think are the four main weaknesses. First, competition decisions in the European Union are primarily the responsibility of the College of Commissioners. These are 28 individuals with limited antitrust expertise. None of the commissioners participates in investigating or assessing evidence in abuse of dominance cases. And the second is that although firms accused of dominance are entitled to respond. They're entitled to know what the allegations are. They are never entitled to a presentation of evidence and arguments before the actual decision makers. They are never entitled to present a full evidentiary and economic arguments before the actual decision makers. In the EU, the European Commission hearings are held before an agency official who lacks any substantive decision-making authority and who has only limited procedural control over the conduct of proceedings. Third, the entire enforcement process leading up to the Commission decision is conducted within a single Directorate General of the Commission, DG Comp, with very limited external supervision from other Commission services and no meaningful separation between those individuals who investigate cases, who formulate the objections, and then who evaluate the objections in light of the evidence as the matter proceeds up through to Commission decision. And finally, although Commission decisions, competition decisions are subject to judicial review, the EU appellate process is extremely prolonged and generally provides a very broad margin of discretion to the Commission. And I think these institutional characteristics and procedures tend to reinforce the other doctrinal circumstances, the substantive views that Professor Manny addressed, that give rise to a much more interventionist and in many respects more uncertain prohibitions on dominant firm conduct relative to the U.S. Now, of course, the chilling effect that's been mentioned is extremely important here because both U.S. monopolization rules and the EU abusive dominance standards are enforced with very heavy remedies. An American firm that is subject to a monopolization case can be simply broken up the way that the Bell system was broken up or the way United Shoe Machinery Corporation was broken up. And many of these companies suffer hundreds of millions or even billions of dollars in damages as a result of private treble damage suits under our statutes. And of course, the EU, as you mentioned in your opening remarks, Mr. Chairman, imposes multi-billion-dollar fines and has not hesitated to do so on a variety of companies. So the huge consequences of antitrust enforcement compel firms to follow the law to the extent they can perceive its limits. Antitrust enforcement should pursue only those approaches that clearly justify the imposition of this type of burden on private sector firms, lest innovation and creativity be subject to this chilling effect that could have significant adverse economic consequences for us. For these reasons, I think the U.S. antitrust standards and procedures are better targeted and better tailored to the objective of maximizing innovation and economic growth and productivity than in the case of the EU. So I will conclude my summary there. Thank you.
Thank you. Professor Fox.
Thank you, Chairman Lee. Thank you, Ranking Member Klobuchar, and members. I do appreciate your having these hearings. I am very happy to present my views on the differences between EU and US abusive dominance and monopolization. What I would like to do is to say a word about the evolution of each system, because I think that each system is grounded in its own roots, and then to talk a little bit about presumptions that I think have really caused the systems to diverge, and third, to mention the implications for big tech and big data. I also want, lastly, to say a word about, is it true, as some have contended, that the European Union is simply suing the US big tech firms because they are so successful, and I want to say a resounding no. So to start at the beginning, the two systems did grow from different roots. The United States system, beginning in 1890, grew from an idea that there was huge raw power among the trusts, and it wanted to condemn the power, not then a consumer welfare standard, but simply against power so that all people could compete on their merits. The system changed quite dramatically with the Reagan administration in the 1980s, in which the U.S. system became very concerned with efficiency, and in my view has led into a great conservatism, especially of the U.S. Supreme Court, especially in matters of monopolization, where the court gives great deference to the dominant firm and wants to unleash the conduct of the dominant firm, except in a very, very small margin. The European Union has different roots. It has roots in wanting and needing peace in Europe, and doing that by economics and by establishing a community of free movement. The threats in establishing, or challenges in establishing the free movement were twofold. One would be that firms would try to put the barriers up that were torn down. The other is that the states, member states, would establish anti-competitive barriers, and the European Union is very progressive in pursuing both elements. It does condemn certain state anti-competitive action, that is the member states, and it pursues private anti-competitive action. In comparing the two systems, there is a divergence, especially Section 2 of the Sherman Act versus Article 102 of the Treaty on the Functioning of the European Union. The biggest difference can be seen by the treatment of duties to deal, refusal to deal, in which the U.S. law under the Supreme Court has great latitude, enormous latitude for a firm to refuse to deal, whereas the European Union, when it sees certain power being exercised in ways that it believes are anti-competitive, feels much freer to intervene. And it feels freer to intervene on behalf of both consumers and innovation. In other words, as Professor Kovacic said before, the two systems are really trying to do the same thing. They want to serve consumers, they want to serve innovation. The EU is much more emphatic in saying we want to serve all players in the market, but not protecting inefficient firms. Implications for big tech, big data. I think the European Union system is simply better positioned to see power and attack power and uses of power. They do not attack mere size, but they do challenge behavior that tends to raise barriers and keep smaller firms out. And they have more flexibility under their 102 than we have under Section 2 of the Sherman Act. Federal Trade Commission, in my view, has this flexibility. We see many new behaviors today, especially by the big tech firms, trying to put up moats around their own system. They've done a lot of good, but they're trying to keep emerging competitors out by suppressing those who use their platform, taking data from those who use their platform and using it for their own purpose, gobbling up the new threats that they see in the way of competition, inserting various clauses so that interoperability is difficult. And I think that we can learn some lessons from looking at the European Union in the way in which it examines the anti-competitive behavior in the big tech areas. The US is far behind the EU. Germany, European Union itself, also now Australia, have come out with proposals, even for further study, of how the big data firms are suppressing, oppressing, and exploiting. And I agree with Ranking Member Klobuchar that it's time for the United States to be taking a more active position. Thank you.
Mr. Cantor.
Chairman Lee, Ranking Member Klobuchar, members of the subcommittee, thank you for inviting me to speak with you today. I'm honored to participate in today's discussion, and I'm humbled to appear alongside my fellow panelists. I deliver my remarks through the lens of an antitrust lawyer with approximately 20 years of experience. That experience includes appearing before state antitrust authorities, federal antitrust authorities, and European antitrust authorities. I've had the pleasure of working in private practice as well as the U.S. Federal Trade Commission. I should note that my remarks today are my own. They don't necessarily reflect the views of my law firm or its clients. But as the humble practitioner on the panel, I guess you can consider these chronicles from the front lines. So I'd like to share a few observations. First, before examining EU competition policy, it's helpful to understand the origins of our own antitrust laws. Antitrust is inherently a U.S. concept deeply rooted in the founding of our country. The framers of our Constitution were primarily concerned about concentration and abuse of power. This included concentration of political power, which resulted in a government with checks and balances as decentralization, but they were also concerned about economic power as a threat to political liberty. By the close of the 19th century, it became clear, including to Congress, that concentrated economic power could pose as great a threat to liberty as political power. In response to the age of the robber barons and industry trust, Congress passed the Sherman Act, which has been hailed by the Supreme Court as the Magna Carta of free enterprise. In 1914, Congress passed the Clayton Act, primarily to address mergers and acquisitions, among other things, and they also created the FTC and the FTC Act. After World War II, interestingly, the U.S. sought to export antitrust law as a means to promote free and open democratic societies. The U.S. insisted on the development of a German antitrust law following World War II. That German antitrust law is the foundation for the European antitrust law that we're discussing today. It was at the urging of the United States following World War II, based on concerns that concentrated economic power led to the fascism that resulted in the rise of the Nazis. Following World War, frankly, the United States also worked to develop antitrust law in Japan following World War II as well. After World War II, we even strengthened our own U.S. antitrust law by closing some loopholes related to asset acquisitions in the Clayton Act. It's worth noting that as we sit here today, these antitrust laws, their original text remains largely, if not completely, unchanged. And I will observe that we have many antitrust laws on the books. Not one of them uses the phrase consumer welfare. Indeed, a plain reading of the antitrust laws and the words on the page, the text of the antitrust laws, demonstrate that the objective of antitrust is to protect competition in the competitive process. It's therefore that my view that we should not be too quick to judge how other countries enforce their own competition laws, and instead, as Senator Klobuchar mentioned, we should remain focused on how best to apply our own. In comparing the US and the EU, there is a tendency to portray a wide gulf between the two jurisdictions. I believe this view is misplaced and that there are overwhelming similarities in the two regimes that largely outweigh any differences. The laws in the books really are substantially similar. If you look at the text, they both address agreements in restraint of trade, monopolization, and mergers. So if our laws are so similar, why do they sometimes diverge in the treatment of specific cases? To me, that divergence reflects a difference in recent views around policy and prioritization, in many sense political-oriented questions. Not partisan, but political. Specifically, Europe has become more proactive in addressing and pressing questions about technology markets. This should not be surprising. The global economy is experiencing transformation of historic proportions. Business models that were once unimaginable 1 or 2 decades ago are now commonplace, and there's a major transition that's occurring in our economy. Europe has pursued a process which includes bringing new enforcement cases so that it can develop the law to reflect changing market conditions. It is important, at least to me, that the United States should not adopt a policy of reactionary contrarianism. Instead, the United States policymakers should vigorously explore, as they are doing now at the FTC, new questions in antitrust to ensure that our own laws and law enforcement regimes remain relevant to the realities of today's economies. Otherwise, we have a greater risk that there will be a tendency to want to engage in regulation. And although regulation may be appropriate in some instances, it's my firmly held view that antitrust law enforcement is a better way to protect and promote the free market economy. To quote the great FTC chairman Robert Pertofsky, antitrust is a deregulatory philosophy. But if you're going to let the free market work, you better protect the free market. Thank you very much.
Thank you very much. Your opening statements have been very, very helpful, and we're going to go now into rounds of questions, and I will begin. Professor Kovacic, I'll start with you. In your written testimony, and in your testimony today, you dispute the often made claim that the EU protects competitors, but the EU's view that dominant firms have a special responsibility with regard to weak competitors suggests the Europeans believe rivalry should be protected, even when doing so would reduce economic performance. Doesn't this in effect mean that EU antitrust enforcers are enforcing competitors, are protecting competitors rather, whether intentionally or not, rather than just protecting an open competitive process, competition for the sake thereof?
Thank you, Mr. Chairman. I would offer another interpretation of that process. I do think there are different perceptions in the United States and Europe about the resilience of markets. And there is perhaps a greater faith in the U.S., although that faith is being tested by a robust debate today, that the capacity of firms to enter markets and to challenge positions of significance is greater than that perception is in Europe. I think there is a sense in Europe that once firms disappear, that there's not going to be someone showing up in a relatively short period of time to take on the incumbents. So I do think there is a difference in perception in Europe and in the United States about the resilience of markets. And if you think the resilience is greater, you're more likely to let firms play without intervention. If you think that that resilience is limited, you're more concerned that the disappearance of an individual competitor is going to distort the political process. And without trying to psychoanalyze either jurisdiction, which would not be appropriate, I do think there is a different view about how robust those markets are, and the U.S. approach has been guided in many ways by the sense that those markets are more robust with respect to capital formation, capital markets, entry. So I would attribute the different perspectives in many respects to that difference in views about market resilience.
Thank you. Mr. Manning, do you agree or disagree with that? In other words, is it an unfair characterization to say that a natural byproduct of EU competition law enforcement is that it protects competitors rather than competition?
Thank you, Mr. Chairman. I think the way you just put it is really appropriate, byproduct. I think it's accurate to say that it's not the primary doctrinal motivation of the Commission, although I will note that, as Eleanor pointed out, the Commission does pursue goals like, revolving around the market integration, which at times can, in fact, mean that it needs to think about particular competitors in the service of integrating the European market. But even leaving that aside, I think the problem is really not so much that they specifically pursue that goal as that there's no constraint on their ability to do so if they choose to do so. So Bill suggested that that part of this comes down to our perception of how well markets function, but we're both aiming at consumer welfare and efficiency. And the difficulty is that the way I see things playing out in the European Union is that they don't really they're not obligated to demonstrate that anti-competitive harm will result absent their conduct, that the loss of a particular competitor is actually harmful. And so you see in the recent Google shopping case, for example, a massive opinion, 270 some odd pages, the entire analysis of which goes to the fact of the underlying conduct that they were complaining of, and none of which goes to demonstrating that the potential loss of the competitors at issue there actually harmed consumers. I don't know for sure whether that's intentional or not. What I can say with certainty is that it's absolutely permissible in the EU regime, that it will persist. There's no great chance that the court will reverse that decision, and I don't think it would persist in the US. I don't think you could bring that case without a clear demonstration of anti-competitive harm, and the result is that, like in that case, you can end up protecting competitors claiming it's for the benefit of consumers, but without actually having to demonstrate that.
Right. So in other words, the analysis, the analytical rigors are not there to make sure that consumer harm is occurring as a result of that.
I believe that's right. I think, and in particular, I think it, at least at some level, comes from the weakness of judicial review. Senator Klobuchar pointed to what she sees as the problems of the judicial review we're getting from the Supreme Court here, and we can talk about that as well. But let's at least recognize that you can readily go much too far the other way as well. And if you're relying on something like judicial review to constrain your antitrust enforcement to ensure that it does actually benefit consumers, that's certainly not happening in Europe.
Can you help me understand why this would have evolved that way in Europe where it didn't here?
I suspect that Eleanor will have some great feedback on this, but I think it's not irrelevant that we have a common law background, and that's a civil law background. That doesn't entirely lead to this distinction, of course. The other thing I think is the nature of the underlying statutes. We talked about it a little bit. You know, the Sherman Act is, 16 words long, and it has, intentionally, from the start, it was intended to be imbued with meaning through the courts. I think you see that in the legislative history, not that I think that particularly matters, but I do think that that's how it's happened in our country. The statute is vague. The consumer welfare standard is not mentioned in the statute at all. Over 100 years of many, many judicial decisions, that's evolved as the appropriate sort of touchstone from the judiciary. I don't know the exact numbers, but how many cases have there been in Europe sort of reviewing and interpreting their statute? They're younger and all of that, but it's a lot fewer because of the nature of their institutional process, as Tad mentioned. So I think it was very much intentional in the United States, and I think it's also very much intentional in Europe because, as I said, the Commission is a political body. It's not inappropriate for Europe to operate under that system, and I don't mean to imply that it is. I think Jonathan is absolutely right. I don't want to impugn their system for themselves. The problem is trying to import that system here, or something like it, as Senator Klobuchar says. No one's trying to bring in the European system, but a system that, in particular, doesn't operate to constrain enforcement, and particularly politicized enforcement, as much as we currently do here. I think is inappropriate for our regime. Even though it may be perfectly appropriate for you.
Oh, thank you. That's helpful. Senator Klobuchar.
Actually, Senator Blumenthal is going to take my turn, and then I'll go.
Thank you very much, Senator Klobuchar. Thank you, Mr. Chairman. Thanks for having this hearing, and thanks to all of our witnesses. I'm going to try to make it to another hearing and then come back. But I just, as a one-time antitrust enforcer, as a state attorney general, I have very strong feelings that what we lack in this country is will. That is, the determination to enforce laws. We may talk about improving those laws. We do so here, but laws unenforced are essentially dead letter, no matter how good they are. Earlier today, I sent a letter to the Department of Justice and Federal Trade Commission urging that they open an investigation into Amazon's use of price parity provisions. They're also known as most favored nation clauses, and they are done with third-party merchants. Around this time of the year, when literally millions of Americans are going to be using Amazon to shop for the holiday, little do they realize that they are likely paying higher prices because of this obscure, seemingly invisible clause. The clause prevents merchants from charging lower prices on other online sites. And I'm concerned that these price parity provisions may be hurting consumers by artificially raising the prices of goods these millions of Americans will be buying this holiday season. Amazon's price parity provisions prevent sellers operating on its site from selling their goods at lower rates on other online marketplaces. That means, as the experts before us know well here, that third-party merchants who sell online marketplaces with lower transaction costs cannot pass on these savings to consumers. And relatedly, e-commerce sites that want to compete with Amazon to attract sellers to their sites have less incentive to offer third-party sellers lower fees, given that third-party sellers couldn't pass these savings on to consumers. if that's true, price parity provisions act as a barrier to entry from competitors. They are an antitrust violation, potentially a violation of our laws. And you also know that the Second Circuit has ruled on these kinds of most favored nation law provisions as recently as 2015, saying that they can be a violation of antitrust law. European enforcers began an investigation in 2013, and lo and behold, as soon as the investigation began, what did Amazon do? It ceased these practices, but it continues them in the United States. So I want to just ask our panel, and I don't have a lot of time to do it, whether you have reservations about this practice, and do you think that American consumers deserve less protection than European consumers? Let me begin with Mr. Cantor.
Thank you, Senator. It's an excellent question. I won't comment on the specific example because I'm not deeply familiar with the facts, but I will say that to observe your remarks about a law that's dead letter or a law that's unenforced is dead letter. And I think antitrust enforcement, particularly government enforcement, serves an important deterrent value. And the more it's enforced and the more companies are understanding of where the boundaries lie, that deterrent has meaning. And so certainly the types of issues you're talking about, generally speaking, seem worthy of investigation. And I do think it's critically important that enforcement and the antitrust laws not become dead letter.
Thank you. Professor Fox?
Thank you. I agree. I want to reference your first statement, law unenforced would be a dead letter. And I want to link what you've just said, because I agree with you. If Amazon is using most favored nations clauses as a barrier, as a moat, to make it very difficult for those who have something to offer to consumers, better price, better product, and they can't do it because of this barrier, that should be illegal. The law should be enforced against it. And I want to link what you have said about barriers to EU competition law. And I know this was not your question, but if there is some time, I want to refer to Mr. Manny's statements about EU competition law, because I don't agree with them all and want to say something about what is consumer harm and does the EU require proof of harm. But here on the barriers, this is exactly where EU law is very concerned with barriers to entry and is very concerned with access of outsiders and wants to protect competition on the merits. And if people are frustrated from offering what they have to offer to serve consumers in a better way, that is a competitive harm. Thank you.
My time is about to expire, but anyone who has thoughts about this issue in writing, I would very much welcome them. And I don't want to take additional time because Senator Klobuchar has been so generous in yielding to me. Thank you.
Senator Klobuchar.
All right. Thank you, Senator Blumenthal. I have a few questions here. I thought I'd start with you, Professor Kovacic, and that is that less than a year ago, at an April 2018 panel, I think, you suggested there is a perception that enforcement in the United States has become, quote, timid and, quote, passive, and that Europeans have felt they need to become the global leader in antitrust enforcement policy because the U.S. has defaulted. Those are your words. Do you still think that the U.S. has defaulted? What should we do about it?
I think that the Google experience in the U.S. Did create a strong impression in Europe that the U.S. could not perform. There was a great run-up to that case. It was highly publicized. The FTC devoted a lot of attention to suggesting this was going to be a signature piece. It assembled a dream team of analysts to work on the case, and then it closed the file. I think to European observers whom I have spoken with a great deal, that was the sense that if in an ideal circumstance you had the votes on the commission, where you had arguably a supportive administration, you had the dream team of advisors, and all you would do is close the file, that was seen as a very bad sign. I do think that the U.S. program is more robust, perhaps, than is perceived. I turn back to the program the FTC is running now. The Qualcomm case is an enormously important case for the future of U.S. doctrine. The Shire case, which is running in the Third Circuit, is a very important case for U.S. doctrine. The FTC is running cases now that could move these boundaries, but it's going to bump into exactly the barrier that you talked about before. But I do see the willingness of the agencies to do it.
You mean the law, the barrier would be the Supreme Court?
The jurisprudence, yes, exactly.
I like
if there were no
Minnesota
political
euphemism.
will,
Very good.
these cases would not exist.
All right, okay, appreciate that, thank you. Professor Fox, you have written that the U.S. has gone the direction of antitrust minimalism in applying Section 2. You've also said that there's problems with the law when it comes to technology. Does this suggest that our antitrust agencies can do more, or that we need to, or it's court, or it is our laws? You know, what would you start if you could wave a magic wand to improve things?
Well, to begin with, I think that our Federal Trade Commission does have the power to look at these problems and to do something to solve them if they believe there is a problem. So I think under Section 5 of the Federal Trade Commission Act, it is ample enough. I think under Section 2, it's not ample enough. I think that it is so non-interventionist. Because it has gone in such a direction, it's actually lost resonance with the rest of the world, which goes much more in the direction of European Union. I don't at the moment suggest revising Section 2 of the Sherman Act. This is a very difficult, delicate thing to do. I think that your bills, which are about mergers, are helpful and useful. And so with a combination of your bills to make merger enforcement more aggressive and more satisfactory, and Federal Trade Commission initiatives to protect against very negative conduct of big data companies, that we would be in a much better shape.
Okay. Mr. Cantor, large technology companies, as you know, have bought a lot of innovation tech startups. But as the director of the FTC's Bureau of Competition has noted, these kinds of acquisitions can be anti-competitive if they foreclose the growth of a potential rival that could one day unseat the large firm, or maybe even unseat the large firm in a certain area of their business, not in all areas as you look at what these companies are doing. Preventing anti-competitive mergers is a priority. That's why we did the bills that Professor Fox just mentioned. Do enforcers in the U.S. and Europe give appropriate scrutiny to acquisitions of potential competitors by large tech companies, and what more should they be doing?
Sure, it's a great question, and I think there are good intentions to a large degree in this space, but a failure necessarily to act on those intentions, and that flows from a lack of rigor that's been developed to address these questions and have tools and rules of the road in terms of how you spot a nascent competitive threat, how you treat disruptive paradigm shifts. And so I think there is a gap in the United States in how to treat these issues. And the absence of guidance, both from the agencies and from the antitrust community, had sort of left it largely untouched. And I commend the FTC for conducting hearings to address these kinds of issues. And I think as we look forward to a new economy with different rules of the road for how businesses have to behave, we need to think about how those rules of the road should look for antitrust enforcement so that it remains relevant.
Thanks. Does anyone else want to chime in on this? Mr. Mann, Professor Lipsky?
I'd like to, if I may.
Okay.
So I have a couple of things to say, but I know your time is limited, so I'll just address one. I think it's a risk to count enforcement actions and point to that as a successful regime has more enforcement actions and a less successful regime has fewer enforcement actions. Our regime certainly has a deterrent effect. The FTC and the DOJ are certainly active when it comes to things like the concern that Senator Blumenthal raised. I assume the agencies are out there watching these things, and not just the agencies, but the states as well. The fact that they may not bring an action
assume
may
it, but
mean-
remember, these are like trillion-dollar companies. We haven't really changed how we're funding our own antitrust enforcement. So as they get bigger and bigger and more complex, just as Congress, for a variety of reasons, hasn't been a counterbalance, you might not have a counterbalance with this either. Not to the extent that you would want.
So, I mean, it is possible. I haven't heard that the agencies say that they are that they haven't brought cases simply because they don't have the resources to do.
Well,
I mean,
the head of the
they do claim
FTC
that
did.
sometimes,
They liked the idea that we looked at some of these mega mergers and putting a fee, which is a drop in the bucket for what they're paying lawyers and business people, to help to fund the review of some of these deals. So.
Sure, and I don't think that's inherently problematic. Again, by the same token, that you can't say that more enforcement is inherently better.
But how about this issue of
that
that I talked about with Mr. Cantor about buying your direct competitors, the small guys, and then basically if the plan is to make sure they're not a threat in a certain segment of your business.
So the problem is that, as I said in my testimony, the same conduct that you can describe as anti-competitive can always be pro-competitive. Mr. Blumenthal's example, for example, he pointed to the possible effects on competing platforms. I'd also like to point out, however, that the effect of what he described would keep prices lower on Amazon's platform. To the extent that more people are shopping on Amazon's platform than other platforms, they're receiving the benefit of that policy. Now, that's not to say that those benefits necessarily outweigh the costs, nor is it to say that the kind of thing you're pointing to can't potentially be a problem. But before we just assume that because we can describe a potentially anti-competitive scenario around them, it doesn't mean that it is in fact anti-competitive. So these companies buy other companies all the time. They improve their own products. And again, just like I was saying with respect to Amazon, when Facebook, for example, improves its product, it benefits, 5 billion users of Facebook. When a small competitor improves its product, it benefits, let's say, 100 million users. Now, that doesn't mean that that competitor couldn't eventually be an important restraint, but you can't discount the fact that the benefits of the incumbent, if it has a lot of uptake, if it's providing benefits to consumers, that improving itself is a benefit today, right here and now, that's measurable and apparent. And what you're describing is a theoretical potential harm in the future.
Okay, Mr. Kovacic, last answer, and then we'll go back to Senator Lee.
Thank you for letting me come in on this question. I think if the agencies today had the evidence that backs the hypothesis, I think they'd bring that case. I think they would bring the case where they saw that intent. So maybe they're more attuned now to looking for that scenario, and I suspect they would. I do tend to doubt that Section 5 of the FTC Act has the elastic potential that Eleanor referred to before. And this may be an area where the Congress has to come back in and give the FTC a distinctive government-only tool, not subject to the spillover that I referred to before about treble damages, to allow the FTC to play this role. The FTC, if we ask, how many times has the FTC won a Section 2 type case under Section 5 before the Supreme Court in its history? That would be never.
Just guess that was the answer.
This has been the courts have applied a terribly limiting interpretation to it. I think that's worth revisiting, to say it's the government of the United States, it's not a private treble damage litigant. And a model I would think of comes not directly from the European Union, but from the United Kingdom, where the United Kingdom has a mechanism that permits the examination and challenge of behavior or circumstances that impose an adverse effect on competition, and to impose remedies without having to show that the behavior or the structure in question violates existing competition law standards. I do think there is room for the U.S. to rethink its framework and to create a mechanism that allows the FTC to fulfill the potential that Professor Fox referred to.
Okay. You want to let Mr. Lipsky answer too? Okay.
If I may, I'd like to point out something that is both, in a sense, a refutation of what Chairman Kovacic has proposed, and also responds to something that Professor Fox pointed out, and I think we heard from that side of the dais and other places at the table, which is there was a time not so long ago when there was no limitation from the Supreme Court whatsoever on what the FTC and the Department of Justice wanted to do under Section 5 or Section 2. And if you look back, for example, because the hearing is focused on Section 2, look at the language in the Alcoa case from 1945, where Judge Learned Hand basically says, if you become a monopolist, you are liable for monopolization unless you can prove that it was inevitable, something thrust upon you. So back in the day, which lasted at least until, say, the early 1970s, when the agencies were perfectly free to take that legal authority and pursue the kind of case that is being urged here against these technology companies or whoever now in the American economy, the result was in re Exxon, in re Kellogg, US versus IBM, and a whole list of efforts to challenge power and challenge access, as Eleanor has suggested, which I'm glad to say none of those succeeded. I think the American economy and the antitrust field is much better because none of them succeeded. And in fact, Chairman Kovacic can give you the site because he was the one who evaluated all of these efforts in a law review article not so long ago and described them. I think his phrase was monuments of prosecutorial ineptitude. So
Sorry,
let's
as
not
having that former job, that would be a scary description.
let's not forget. Let's not forget these very clear lessons of fairly recent history about wanting more authority from the courts and just seeking.
I understand. I just don't. I think that our economy has continued to grow over time. So what I'm concerned is, back then, did we have a situation where you didn't have the internet, but where people were, talking to their mom or their friends about what movie they wanted, and that someone actually took that conversation, which is now post on Facebook, and gave it to a bunch of companies so they could target them for advertising on their movies. I don't know. I don't think they were listening in on their conversation. So my point is that we have now unleashed what are essentially dominant media firms in certain areas, highly successful, employing a lot of people, but is it really working for the average American?
Well, there are many reasons. I completely agree. Every new industry, every new technology presents its own challenges and its own issues. And it's great that we have a statute that has the generality, the constitutional generality, the Magna Carta generality of Section 2 of the Sherman Act, so we can look at these new issues and decide what the appropriate response should be. But it should always be with the basic objective of using the best analysis we can bring to bear to protect the process of dynamic competition with the ultimate objective of making our economy and our consumers as well off as possible.
All right, thank you.
Professor Fox, Mr. Manny suggests that you might have some insight on the question I asked him about why it is that the European system evolved differently than the U.S. system. Do you care to opine on that?
Yes, thank you. The European Union system is based on community within the internal market. This fits really seamlessly with the idea that firms ought to have a right to contest markets. It fits with the free movement of firms across borders. And so the European Union ended up with rights of access. I mean, not absolute rights of access, but rights of access so that firms that are challenging markets are not frustrated from entering because of practices that are considered abusive by a dominant firm. I know abusive needs definition, so you need to know what those practices are, but they are conduct such as a company which hosts a platform preferring its own, demoting its rivals, or having anti-competitive clauses such as preventing interoperability. But so this means that the EU starts from a point of access on the merits, whereas U.S. starts from a point of saying in Section 2, no intervention unless the plaintiff can prove that output is limited. And in many of these cases, probably there's no limitation of output in these big data cases, probably not cases about limitation of output, but maybe cases of frustrating rights of competition on the merits.
Thank you. That's helpful. Did you want to respond to that, Mr. Manning? Yeah.
I agree. I think, though, I just want to stress that the putting integration, even entry, giving it primacy over consumer welfare effects is not necessarily good for consumers. It may be appropriate for the purpose of European integration, but you can't say that just because we're improving, perhaps, the rate of entry or contestability, that we're improving things for consumers. The DOJ, for example, brought a case against Apple as it tried to contest and enter into a market and argued that it was acting anti-competitively. It was not sufficient for the Second Circuit that Apple tried to say, well, hey, we're improving competition here. Because, rightly or wrongly, the Second Circuit determined that that was not the likely consequence of what they were doing with respect to consumers. So don't disagree, but I just want to stress that that is a very different maximand than what we think we have in the U.S.
Okay. Got another question for Mr. Levski, but let's go to Mr. Cantor, who wants to weigh in on this.
Yeah, no, it's a terrific question and provocative, so thank you for asking it. I just wanted to build on something that Professor Fox said, because I think it's a helpful illustration, and it feeds into questions you've asked and questions Senator Klobuchar asked. You know, at some point, the antitrust laws, converted to, the goal of antitrust law being to manage, in the United States at least, efficiency and output. But now we have markets where it's very difficult to quantify output, and it's very difficult to measure efficiency. And so I think we are starting to see some of the challenges and limits of that narrow approach. And some of the calls for advancement and movement into new ideas is in large part designed to make sure that we're not relying on old economics and old economic principles that are baked into the law that don't reflect the realities of transformed marketplaces. And I think measuring output in the context of some of the things we're discussing is it just that 1 and 1 doesn't equal 2, and it's impossibly difficult and sometimes often irrelevant to the goal of the antitrust laws, which at the end of the day really is competition. The antitrust laws exist because we value the competitive process. We're not trying to engineer markets. We're not trying to central planning to ensure that everything's efficient. We believe the free market and competition will ultimately yield benefits for our society. And if we focus too much on this ideal of efficiency or output, we lose the feel of the antitrust laws, and they become almost impossible to apply. And I think that's one of the challenges we're facing right now.
Thank you. Professor Lipsky, you wanted to add something. Feel free to add that, but I also want to ask you a question as you add that. In the United States, under our system of laws, firms that achieve market power through legitimate means are not expected to pull competitive punches in order to prop up their rivals. It's just not something we do. It's not something our laws require. But by contrast, in the European Union, such firms have what's known, I believe, as special responsibility.
Right.
To act as much as possible as if they had no market power. That seems to me to be frighteningly broad, vague, and uncertain. So how are firms supposed to know how to operate in the EU under this this special responsibility mandate?
Well, I think it's extremely difficult, and I think that's why I would fear the chilling effect of adopting that kind of a principle in EU law. I think it is a cogent criticism of the way EU competition law is enforced. I would draw your attention to the article cited in footnote 9 of my written submission, which is an article written by a very distinguished and thoughtful and dedicated lawyer who used to be the chief antitrust lawyer for the legal service of the European Commission I suppose you could say he was kind of the antitrust solicitor general for Europe. And he has a somewhat more bare knuckles defense of the European approach than others on this panel have suggested. He basically says, well, the Americans claim that they have an economic approach, and they say that means you want to maximize productivity and economic growth, but it's just as good an economic proposition that rivalry has an independent value. But the problem with that assertion is that economics is ultimately about how well the economy functions and how much wealth is being created with your scarce resources. And if you're saying we value rivalry for its own sake, despite any possible cost, you're really adopting rivalry and the preservation of competitors as an objective in conflict with the idea of economic growth. And I think in response to Mr. Cantor, there has to be a distinction between the ultimate objective of antitrust, the guiding principle for the interpretation of antitrust law, and the recognition that the policy instrument of the antitrust laws, and I think we totally agree on this, is competition. But it's different to say, well, we're trying to maximize output in every case. No, we're not. We're trying to preserve the dynamic competitive process to the end that economic growth and productivity will be maximized. It's only in the difficult cases. This is not an issue in a price-fixing case, because we're totally convinced, based on economics, historical record, observation of the way industries functions, a horizontal minimum price fixing is bad. It ought to be condemned. We prosecute it criminally. We don't worry about anymore about whether that rule serves economic growth. We're very confident that it does. It's only in the hard cases, and of course most of the Section 2 cases involving things like low pricing or product bundling or activity that is ambiguous in its ultimate competitive effect. That's where we want to have the courts discipline the enforcers to think clearly about whether the rule about competition that's being applied in the specific case will or will not enhance economic output. So I think that distinction sort of helps to sort it out.
The key distinction there being rivalry does not equal competition.
Not necessarily.
Rivalry can involve competition, but it's not the same in and of itself. In other words, the achievement and preservation of rivalry is itself not sufficient to maintain competition.
Correct. And when particularly when we look at innovative activity, where a firm will make some great invention and get a patent, and implement that patent, license it, and produce products with the technology in a way that maximizes its profits, precisely because that conduct has arisen by virtue of the exact behavior that we want to encourage, innovation and invention and commercialization, precisely because all the elements of that behavior are favorable to the competitive process and to the maximization of our economic wealth. We say no, you should not force the sharing of that technology with other firms who have contributed nothing to it. The mere enhancement of rivalry is actually in contradiction to the basic objectives of the antitrust laws.
As international commerce, including e-commerce between the United States and Europe, continues to increase, as the pace of commerce continues to accelerate with the pace of technology, you think we will see differences? I mean, these differences perhaps in the past wouldn't necessarily manifest themselves in big economic differences between Europe and the United States, but would you expect those to become more obvious in the years to come?
Well, I think there are some who compare economic performance between Europe and the United States and conclude that actually whatever we're doing here is working better than whatever they're doing there. I'm not advocating one way or the other. I think Professor Manny has a lot to say about that, but it certainly could be, as you say.
Okay. Thank you. Senator Klobuchar.
Okay, very good. Mr. Manning, did you have anything more you wanted to say on the innovation question I asked?
Will you remind me of the question? I'm sorry.
Yeah, that's good. Okay, well, it was about if whether or not this purchase by the tech companies of the smaller firms is limiting innovation.
Well, actually, I would sort of point to what Tad just said. Excuse me. You can't count the number of competitors and from that determine the competitiveness of a market. And part of that is because of things like scale effects and upfront costs and the wide range of market structures that are optimal or as best we can achieve for any given set of circumstances, which themselves vary massively between every market you ever look at. And in some of these markets in particular, these tech markets, it's very clear that because of network effects, because of scale economy and other things, that a large size seems to be pretty efficient. Now, that doesn't mean, by the same token, that you know, quashing every competitor or something like that contributes to the efficiency of these markets. It really just means that we can't look at that and say that it's sort of presumptively bad. Okay. I think that's, just want to say, particularly true when it comes to these companies purchasing other companies, which was the specific question you asked, as opposed to engaging in some sort of conduct that prevents them from being able to exist, right? That causes them to disappear from the market. I think those are also very different things that go to the dynamic consequences because, of course, purchase by a bigger company is one of the ways that we incentivize entry in the first place.
Very good. All right.
Thank you.
I wanted to give you a chance because someone said on Twitter, they said that I bet no Democratic senator will ask you a single question because you answered in such length and said, I mean, he's like the congressional witness equivalent of the guy who can swim 7 laps on one breath. I thought that was sort of amusing, but I wanted to prove to them that I was not afraid.
Coincidentally, my
medal that we award.
I know that I wasn't afraid of asking you questions at all.
Coincidentally, my written testimony was 63 pages too.
Well,
I have a lot.
Well, that'll be some good nighttime reading
Sure,
for me.
yeah.
Okay, so I wanted to get at online travel agency, something I've been sort of obsessed about for a while. Most favored nation clauses, as you know, or MFNs, are contract provisions. I guess I'll ask you, Professor Foxes, and you, Professor Kovacic. So most favored nation clauses, or MFNs, are contract provisions in which one side imposes limits on the other side's ability to deal with third parties by ensuring that the side imposing the provision will always receive the best prices or terms of trade. While some MFNs may be pro-competitive, I've heard complaints about the common use of MFNs in highly concentrated industries, such as MFNs imposed by online travel agencies on hotels. European national competition authorities have brought a number of enforcement actions against dominant online travel agencies and have forced them to narrow the scope of the MFNs, but U.S. authorities haven't been active in the area. According to Professor Fiona Scott Morton, differences in legal rules do not explain the lack of U.S. enforcement against online travel agencies, MFNs. How could you explain this lack of enforcement? Do you have any thoughts on this? Professor Fox.
Yes, it's true, of course, that EU nations have been active, especially France and Germany. This is an interesting area because a platform is trying to get the lowest price. In fact, it's trying to get a low price, not a high price. But given the MFN, it works out that this raises prices. And there are wide and there are narrow MFNs. And in general, the MFNs seem to raise prices in spite of trying to get a low price. And therefore, I think there probably ought to be enforcement. European Union actually has stepped back and is letting the member states enforce. And I think France has a law that simply prohibits the MFNs, and most European countries prohibit what is called the wide MFNs, which is it applies to all platforms and all competing platforms, and the narrow one applies only to, for example, the hotel versus the platform saying, I won't give a lower price. I think it is something to explore. I think in the US, another reason that explains why there's so little enforcement is because it's written in terms of a vertical agreement. And the US has been much in law under Section 1 of the Sherman Act, in my view. It's been, and also Section 7 with AT&T Time Warner, it's been much too conservative in understanding anti-competitive effects from vertical integration.
Got it. I see. Mr. Kovacic.
Thank you, Senator. As Eleanor said, there's been a very active debate among the member states about the treatment of the practice in Europe. One thing I mentioned in my written paper is that I think there would be a great benefit for the U.S. agencies to consult more closely with their European counterparts to see why, look at the debate more closely and to see why you've seen intervention in some instances as opposed to others as a way of informing judgments about what to do here. I do think there is a lot of room for the U.S. institutions to revisit the treatment of vertical contractual restraints. Since the Legion decision, which you mentioned before, what has been the level of U.S. Federal enforcement involving resale price maintenance? There's a speech by the Department of Justice in 2009, and the FTC approved an order modification at roughly the same time. That's been it. No further guidance, no revisiting of this issue. It's as though Legion became the occasion simply to walk away completely. Whatever the exact form of intervention might be, it's a good place to re-engage. And the discussion with our European counterparts, the member states would be a good place to inform that discussion.
Okay, very good. Last question. Last for the hearing for me. So online platforms, I kind of led with this with the news today, exist in what are often winner-take-all markets, in which they may not have started out that way, but as they get bigger, it feels like that. We are unlikely to see many competitors, I think, no matter what we do with antitrust, at least here in the short term. This has led some to suggest that we supplement antitrust law enforcement with sector regulation of the markets. In the online data protection area, for instance, Senator Schatz is leading a bill, and I'm a co-sponsor, the Data Care Act, which would require online platforms to take responsible steps to safeguard personal information, stop misuse of data. I've mentioned this privacy legislation that Senator Kennedy and I have. In the competition area, the European Commission has proposed a digital platform regulation that would require online platforms to implement measures to promote fairness and transparency. Do you think that Congress should consider legislation? I guess I'll ask you this, Mr. Cantor, Professor Lipsky. Do you think we should consider legislation to address some of the competition issues raised by dominant online platforms, or do you think antitrust enforcement is going to do the job? I'll start with you, Professor Lipsky.
Privacy concerns obviously should be taken very seriously. I think the main question I have in response is, what does privacy have to do with competition and the particular values that are addressed specifically under the antitrust laws? I can imagine scenarios in which the conditions of privacy of customer data or consumer data, which is probably a very significant term of trade, just like a price or how many frequent flyer points you get with each dollar purchased, the degree of privacy, that is something over which competitive providers ought to compete. And that, to some great extent, should be subject to the very same rules that you apply to an agreement on credit terms or anything else.
Right, but what if you don't have competitors for a certain thing?
Well, I think, well, again, you would be using monopolization standards, but I would caution against regulating it as under a kind of a manufactured unfairness concept.
You're talking about instead some of the privacy rules we've been.
Yes, I completely support the notion of protecting the privacy of consumer data to an appropriate degree, but it is something that I think, only has a certain profile in the antitrust lane.
Got it.
It has a
Well,
much
but I
greater
was sort of
profile.
linking them in that this isn't kind of working, and because you want competition to do this, right? You want to have these privacy
Ideally,
rules
yes.
because they're competing, and if you're the bad guy that got all the data out and gave it away, then, well, sorry, everyone's going to go over and not use you anymore. It really hasn't worked that way. And so that's why my argument is, if we can't immediately, if we're not going to use antitrust, and the courts won't, to try to look at this, and you would argue maybe that there's not a real way to do it, then we might have to, it's a way to explain why we are also looking at privacy laws.
Well, it's an
Because there's no
interesting-
way to compete them into doing it. They're not doing it themselves.
It's interesting you say that, because the ICLE that Professor Manny directs.
He's afraid to talk now.
He held a conference. So he's already talked. I'm going to summarize for him.
I've been cut off.
He held a conference not so long ago, and there was a representative of the European Union, a competition enforcer, who basically, somewhat airily suggested that they use the competition power to regulate privacy. And when questioned about it, she said, well, the competition laws are extremely powerful. It's essentially,
Yeah.
and
But we-
I was
yeah, okay,
I was very surprised to hear that I used the expression, to somebody with a hammer, everything looks like a nail.
Yeah, okay, but we're
None of
sort
the
of
Europeans
admitting
had ever
this-
heard that
Yeah,
expression.
but we're kind of admitting this isn't working in that way, so that's why I'm looking at other laws. So I'm going to go to Mr. Cantor, and then we'll end, and then I will be done,
I would just
Chairman Lee.
remark in jest that it's ironic that the filibuster is coming from the panel rather than up there from the
Thank you.
senators.
I like that acknowledgement.
Yeah. So, you're raising an important question, which is, in the absence of competition, regulation becomes sometimes only the necessary tool. And this
That's a
is-
much nicer way of saying it, more direct. Thank you.
And this is an issue that actually Justice Brandeis addressed head-on, and he talked about the distinction between regulated competition versus regulated monopoly. And in his view, the benefit of antitrust was that you have regulated competition, meaning you preserve the opportunity for the free market to create competitive pressure around many dimensions of competition. And that yields lots of benefits. But under, enforcement of antitrust, or the disappearance of antitrust, could lead to a situation where competition can't provide the necessary discipline in the market, and the only solution left on the table is regulation. That's not preferable, at least not from my view. I think a competitive free market is far more desirable than a
Agreed.
regulated market.
Yes, and that's what we just don't have that, but thank you. Last,
May I offer a suggestion?
yes.
Step one, Congress adopts an omnibus unified privacy law framework that replaces the existing collection of pieces with an omnibus set of standards. Step two, it makes the Federal Trade Commission the National Data Protection Authority by getting rid of the ridiculous anachronistic carve-outs which you and your colleagues control. You can knock
we
those
can
out in the
change it.
blink of an eye.
Right.
And step three, the FTC having now the combined consumer privacy and competition mandate, you tell the FTC, pick the right tool and collection of tools to fix this problem.
Okay. All right. Thank you. I really appreciate this discussion. Thank you. And I want to thank our staff and Senator Lee's staff for putting together the panel. They did a nice job.
Every time I hear someone refer to Legion, I'm reminded of the fact that I know the law clerk who wrote the certiorari pool memo recommending a grant of certiorari in that case. Very handsome, went into politics after clerking.
And is wearing a red, white, and blue tie.
Right.
Could he be wearing that
Look,
tie?
I have no claim to fame, and so that's the only claim to fame I have.
I had no idea.
Yeah, I know.
And now I can add that to my opening remarks.
I expect to get a lot more respect as a result of that, which you always show. Okay, couple more questions. Professor Kovacic, you suggested in your testimony, quite persuasively, I think, that there's kind of a one-way ratchet effect in that in the global economy, the jurisdiction, or at least the active jurisdiction that has the most intervention-minded policy has the power to set sort of a de facto global standard, and that and so I guess my question is, does that suggest that the Europeans can effectively dictate how U.S. firms will act globally, including within the United States, according to EU competition law enforcement?
Increasingly, it means exactly that, because it becomes harder for firms, especially in the tech area and these information services sectors, to establish different standards, different approaches for different regions of the world. And what's around the corner, I think, Senator, is that the emerging third force that will become co-equal with the two jurisdictions we mentioned, that will be China. And China goes to school very carefully on what the other two do. It is very deeply influenced by the European model. I think it's a major reason why the United States and Europe should think very carefully about what they want this framework to be, because in a relatively short period of time, it will not be their call.
Mr. Manny, in your testimony, you talk about the chilling effect that can occur as a result of this dynamic. If U.S. firms are essentially forced or effectively coerced into complying or into modifying their business practices in order to comply with what EU regulators want them to do, what might this mean for U.S. consumers of the products and the services of those firms?
First of all, can I just say I didn't know about the Legion thing, and you're kind of my hero now. So.
Fantastic.
I'm
loving this.
Half of the antitrust bar kind of hates you now, but half of us, more than half, you're our hero. So, with respect
like
to
an antitrust Star Trek convention.
Right.
Okay. All right. Okay.
I think that's called the ABA spring meeting.
Not that cool. I mean, almost that cool.
That's a low bar. Now, of course, I've lost my train of thought.
I'm so
yes,
sorry.
no, that was my fault. I think that the problem is sort of as Bill suggested, what happens with these spillover effects. If you care about U.S. citizens, I want to say sort of preliminarily, there is, of course, an inherent cost to compliance with multiple conflicting regimes. This is a totally sort of separate question, and it's a complicated one, but I think it is certainly worth pointing out that that alone presents costs that have to be borne by companies, but that's the nature of doing business in a global environment. The bigger problem, I think, is what Bill suggests, when as an effective matter, there's essentially no geographic boundary to the operation of these rules, and especially when it's China who's doing that. And so I'll take one example, the Android case in Europe, the Google Android case, right? Some of us predicted that what a consequence of the European Union basically saying, this business model doesn't work for us, you need to find a different business model, is that indeed, I think it's the case, someone correct me if I'm wrong, that Google has decided to start charging developers for Android, various things they haven't done before, that arguably will raise the price of the devices that people are buying. Now, whether on net that's a benefit or not, I don't know for sure. Google obviously thinks that it's not a benefit. Most users wouldn't necessarily find it a benefit. And as long as they can, they'll obviously resist sort of, selling at a higher price in the United States, but it's a global company. The effect of the inability to operate their business model in that fashion can't help, I think, but raise prices everywhere, including in the United States. Now, again, we can't say with absolute certainty, which, by the way, is the whole point of everything I've been saying, that it's not an improvement, sort of overall. But we certainly have to recognize that the European Union may be acting for very different reasons, like we've been discussing, and they will effectively be imposing the effects of that on U.S. citizens. I don't think we can deny that. Yeah.
Thank you.
Well, I just wanted to acknowledge Senator Lee's leadership this week, and actually for 5 years on criminal justice reform. It's not our topic today, but he, through 2 administrations, one Democratic, one Republican, he was unwavering and worked across the aisle, and it was really fun seeing him at the front of the chamber last night taking a photo. I won't comment on that as the ranking on the Rules Committee of the final vote. And I started my morning out actually at a Q&A with a conservative and liberal commentator, And they said that Senator Lee had said, in the end, we're going to get over 80 votes for this bill. And they never believed him, and he was right. So I want to thank him for his good work. It was a really nice moment.
Thank you very much. Even a stopped clock is right twice a day, and I guess I had my moment. But then, as those journalists noted, I appreciate your remarks, Senator Klobuchar. It's an effort long in the making. And I guess, I don't know if you can prove that I was actually taking a photo. We're not supposed to use our phones on the Senate floor.
That was just a mistake. I didn't see it right.
We're stuck in the mid-19th century on the rules governing the use of technology on the Senate floor.
Such is life.
Such is life. And given that many of our colleagues started their service during the William Howard Taft administration, it feels appropriate. Sorry. With that, I appreciate each of you coming. No Christmas would be complete without an antitrust hearing on international antitrust policy, and this holiday season certainly feels complete for me because of this. Thank you for being here and for your deep insights. We'll be adjourned, and we are keeping the record open until January 4th, 2019.
Thank you.